Good afternoon. I'm delighted to introduce this technical webinar on the SRA's consultation Looking to the Future. This is the consultation we launched last month. It proposes significant changes to our regulatory approach and how these are reflected in our handbook and more specifically our code of conduct. First thing to do is to introduce myself. I'm Juliette Oliver. I'm the General Counsel here at the Solicitors Regulation Authority. I've been working with our policy team on the regulatory reforms and particularly drafting the new codes which are proposed in the consultation. And I'm joined here with the Principal Legal Advisor in my team, Jessica Clay, and a policy colleague, Amanda Fox, both of whom have been heavily involved in this work and who can help us present these slides and also answer your questions. The purpose of the webinar is to explain our thinking in some more detail and particularly to gather your feedback on our suggestions. And with that in mind, I'm absolutely delighted to say that this has been a very heavily subscribed webinar, and it's great that so many of you can join us. The aim of the session is for me to walk you through a sort of helicopter view of the consultation paper and what's involved. And then Jessica will talk us through some of the aims of the changes in some more detail, referring to particular draft clauses in the codes and using those really to help explore and explain our approach. Amanda will then talk us through next steps in the consultation and some timeframes. We'll hopefully have time for some of your questions, which we'll be gathering as we speak. We may not be able to get to all of them or answer them all now, but we will consider them all and feedback on the issues you raise, both in the FAQs, the frequently answered questions section of our website, or in our response to consultation. So do please let us have your thoughts as we're going ahead, or if these occur to you after the webinar is finished, then go on to our website, SRA Looking to the Future website, and you will see that there are text boxes there you can feed your comments in. So the key aim of our new proposals is really, at its heart, to ensure our regulation is fit for purpose in a dynamic and changing legal market. And what we want to do is to regulate in a way that not only protects consumers and the public interest, but also encourages a strong, diverse and effective legal market and improves access to justice. And these are objectives that have been given to us by the Legal Services Act. And we take them very seriously. And we know that the market is changing rapidly and that consumers are changing the way that they find and use legal services. There's an increase in consumers going to the alternative legal sector, which includes businesses and firms which aren't regulated either by us or by any other legal services regulators. And they provide services that don't fall within the list of reserved legal activities in the Legal Services Act, which need to be delivered through firms which are regulated. And we know that firms, both in the regulated sector and the alternative legal sector, are having to think very carefully about how they can find innovative ways to deliver services and to provide pricing models that meet consumers' demand to do more for less. So what do we want to achieve from these reforms? Well, firstly, to really refocus the debate away from compliance with prescriptive rules towards high ethical standards and professional values, to reinforce what it means to be a solicitor in this increasingly diverse market. And we want regulation to get out of the way of growth and innovation and to provide a more flexible and future-proof regime which allows businesses to develop and compete in a way that really works both for them and for their clients. I think it's really important in doing so that we strike the right balance between reducing regulatory burdens and ensuring appropriate protections for consumers. And I think this involves on our part a recognition that protection may not be absolute and what is appropriate will differ wildly depending on the client and their circumstances. And that a gold-plated regime where no client is ever at risk, even if that were possible, would be impracticable and so costly no consumer would ever be able to afford those services. Our aim is therefore to plug the gap of unmet legal need and increase the availability of highly qualified and ethical solicitors across the market, giving more choice to consumers and giving more solicitors more freedom in where they work. So to that end, a key proposal of ours is to allow solicitors to practice providing those unreserved services to the public, those which don't require the business to be authorised, within firms that aren't regulated by ourselves or other legal services regulator. Currently, solicitors are the only people who are unable to provide legal services within those businesses as a result of our current handbook rules. So what are we doing? We've developed a new, leaner set of fundamental principles which we're consulting on. These describe the values we expect to be upheld by all of those we regulate, solicitors, but also managers and employees within regulated firms, irrespective of context, irrespective of where they work. Jessica will come on to look at those in a little bit more detail, but those principles include, for example, honesty, integrity, the things that can attach to conduct in private life where this raises real, genuine issues around the individual's suitability to be a registered professional and provide legal services. We've also drafted a code specifically targeted towards individuals authorised by us, so that's solicitors, registered European lawyers, registered foreign lawyers. This sets a framework for competent and ethical practice that's directed to the business context, to the practice context. This is simpler and set at a more high level than our current code. The idea is this can be owned and understood by all, and it's flexible enough to apply wherever they work. We've also drafted separately a code for firms authorised by us and the managers and employees working within them. The focus there is on business and compliance systems and key outcomes to protect consumers, such as around conflicts of interest, confidentiality. This distinction between a code for individuals and a code for firms highlights the distinction between the basis upon which we regulate individuals and firms. With individuals, our framework is based on protection of title. This includes setting entry standards and educational requirements and ensuring that those individuals maintain their high levels of competence and ethical standards throughout their career. In entity regulation, we entitle firms to carry out those reserved legal activities by ensuring they have the right compliance systems championed by their compliance officers for legal practice, their compliance officer for finance and administration, backed by certain consumer protections like mandatory professional indemnity insurance, rules around handling client money and that kind of thing. Those kind of protections are not in our current proposals to attach to the businesses that solicitors who work in an unregulated market work within, because we see those as systems controls which attach to entity regulation. So in summary, we believe our regulation can be more effective, and we believe effective regulation can give solicitors and firms the freedom to practice and the freedom to innovate and compete within the growing alternative legal services market, within the increasingly diverse and dynamic market. In doing so, this will increase choice for consumers and crucially tackle unmet legal need, which we know is out there, which we know exists, and make it easier and cheaper to comply by moving our rules to a more high level and a more principled basis. So Jessica, at this point I'm going to turn to you. I think you're going to take us through some of our proposals in a little more detail.
Great, thank you, Juliet. So as Juliet has described, we will have a new revised set of SRA principles. In terms of who they will apply to all solicitors, registered European lawyers, registered foreign lawyers, regulated firms, and their non-solicitor managers and employees, both in and outside of practice. We will also have a revised SRA Code of Conduct for solicitors, RELs and RUFLs. Again, this will apply to all of those that I've just named, wherever they practice, and that could be in a regulated or unregulated business or in-house. And it will include a set of standards which apply also only when you provide services to the public or a section of the public. So in effect, this will turn the approach to the current code on its head, where we have standards and points to note in relation to in-house solicitors, whereas now they will be incorporated into all of the standards rather than being a sort of a second thought at the end. In terms of the SRA Code of Conduct for firms, it's proposed that it will apply to all SRA authorised firms, and that's what the U encapsulates. and it will include specific standards, as Juliet's mentioned, in relation to compliance and systems, and there'll also be specific standards relating to managers and sole practitioners, and also for compliance officers to meet. So a little bit more detail about the proposed principles. Within the proposed principles, they will have some existing SRA principles from the 2011 principles, plus some variations on existing principles, and also bringing across some of the professional principles from the Legal Services Act 2007, and some principles from the existing principles will also be now reflected in the revised standards in the draft codes, and I'll give some more examples in a moment. In terms of code standards and principles, it's expected that they'll be equally enforceable and are not interdependent, and this is to be aligned with our enforcement strategy that we'll give a bit more detail about later on in the presentation. So really the SRA principles are about the fundamental tenets of those we regulate, whereas the standards will be more about expected practice standards, which are more context specific. If we do have any conflict in individual principles, the approach will be that the principle that best serves the public interest in the proper administration of justice will be the principle to take precedence. So this slide sets out our proposed 6 principles. In terms of the proposed principle 1, you'll know that this is an existing principle 1 in the current SRA principles. The new proposed principle 2 is in fact a variation of the current principle 6. Acting with independence, new proposed principle 3 is as currently our 2011 principle 3, but also is a professional principle from the Legal Services Act. New principle 4, we've introduced the element of honesty, but the integrity part is already present in principle 2 of the current principles, and again is a professional principle. The new proposed principle 5 is now a variation on the current principle 9, and we have maintained as a new principle 6, which was old principle 4, and a professional principle to act in the best interest of each client. In the current principles from 2011, principle 5, 7, 8, and 10 have now been incorporated into new proposed standards in the new codes. So I'll move on now to talk briefly about the Code of Conduct for Individuals. This we have managed to reduce from around 30 pages down to about 7 pages. We are now proposing that it's drafted in the format of standards to be met by those to whom it applies, and it will incorporate many of the current outcomes from the existing 2011 code. Many people will be pleased to hear that we'll no longer have indicative behaviours. That said, some of the current indicative behaviours in the 2011 code will become, as part of our proposal, standards in their own right. Others will be covered by guidance or by case studies. We've had some draft case studies put together by the ethics and guidance team, but we are strongly encouraging people that are responding to the consultation to provide more examples from practice of the challenges they face, so that we can actually create more tailored case studies that are more useful to you when trying to interpret the code. In terms of the Code of Conduct for Firms, this is slightly shorter than the Code for Individuals, and this is a newly created code. And to create this code, we have taken outcomes from the current 2011 code, mainly from Chapter 7, which deals with systems, and also taken out the current Principle 8 and moved all of these into new standards in the Code for Firms, and also taken some provisions from other sets of regulatory arrangements, like our authorisation rules and our practice framework rules. So the new Code of Conduct for Firms will cover standards that businesses will need to meet. We are also proposing including provisions which relate specifically to those with management responsibilities, and also a section applicable to COLPs and COFers, so your compliance officers. And the important point to note here is that those individuals will be jointly and severally liable for any breaches by the firm. I'd like to turn now to talk briefly about our approach to drafting these new codes. And a lot of this information you can find in our rationale document, which is Annex 7 to the consultation paper. So to start with, it was very much our intention to create a clear distinction between solicitor and firm regulation. It's very much felt, as time has moved on since 2011, that the existing Code of Conduct has a very much a one-size-fits-all approach, applying to individuals, firms, managers, employees, and this simply doesn't work. We have decided to try and substantially shorten the code by adopting the following working principles in our approach to drafting. We have tried not to replicate legislative obligations imposed on individuals or firms. We've also tried to prevent duplication by removing outcomes if they're covered elsewhere. We want to introduce more flexibility and less prescription to the drafting. And we are confident in adopting that approach because all the time, courts and tribunals are interpreting these terms based on individual facts and circumstances of each case. So this is very much aligned to a case-by-case basis approach and will be aligned to the new enforcement strategy, which we'll talk about in a moment. Another approach is removing indicative behaviours and incorporating them elsewhere, as I've already discussed. And we've also tried to identify areas where protections were lacking or clarity was needed. And by doing so, we've also added new standards and proposing new case studies to cover any regulatory gaps. So I thought now I would discuss just some of the specific features of the new code based on that approach to drafting. So it was our intention very much to create high-level, flexible and purposive standards to be met by those to whom the code applies. And these standards are to be underpinned by a range of case studies and also some new standards, which I'll come to later in the presentation. And another feature of that approach is removing prescription. So I'll talk about both of those in a bit of detail now. In terms of adopting high-level and flexible drafting, a good example of this in the new code is in the Code for Individuals, and there's the standards relating to cooperation, accountability, and information requirements. In terms of the new standards, we're proposing 8 high-level standards in Section 7 of the new Code for Individuals, and specifically standards 7.3 to 7.10. And to create these new standards, we very much reviewed the current outcomes in Chapter 10 of the 2011 Code and also the 14 indicative behaviours. And it's those that we very much replaced with these 8 new streamlined standards. These standards cover things such as the cooperating with your regulators and others, the provision of information, notification of material changes, the need to report breaches, and informing clients of any potential claims against you. We feel that this approach to our drafting has very much captured a range of purposes in terms of cooperation and accountability. Not only is it streamlined, but actually the scope is now broader in terms of the cooperation requirements, in that it covers other regulators and those bodies with a role overseeing or supervising the delivery of legal services. So we've streamlined, but at the same time gone for flexibility as well. In terms of removing prescription, as I've mentioned, the reporting obligations are now significantly streamlined, and this is also mirrored in the Code of Conduct for firms, where we have managed to take a number of provisions from the SRA authorisation rule and the practice framework rule and redraft those into 9 much more streamlined standards, and also taken other elements from Chapter 10 of the current code. So that's all I really want to say in relation to removing prescription in that aspect. Another aspect of removing prescription, which is something that I wanted to focus a bit more on, is the simplifying of language. Some people might say that the language which we have introduced into the standard could be considered as vague or perhaps not very helpful, but in fact we've introduced it to try to avoid rigidity and prescription. Examples of this language, it's very much day-to-day language, are words such as reasonable. For example, in the individual code, we talk about standard 1.3 within a reasonable amount of time. We talk about things where appropriate, so in terms of putting in place effective safeguards. We talk about in a timely manner, so delivering a service, for example, within a timely manner. And in a number of the different standards, we talk about promptly, and that's very much with a view to removing any specific time limit in each context. So by creating some extra flexibility by removing prescription and having to be wedded to very prescriptive words. But we think this wording also will introduce more flexibility, and it will require those relying on the code to use their own judgment when applying the code to their practice and conduct. And again, this aligns to our enforcement strategy and our approach, which we will be reviewing later this year. The second feature I wanted to talk briefly about is the removal of duplication. Duplication features in terms of duplicative regulatory obligations and also legislative requirements. So it's very much our intention with the new drafting to delete provisions which exist elsewhere, provisions which are potentially no longer required because they're already imposed by the legislation, or are no longer required under our proposed reforms in terms of policy approach. So this could include things such as removal of references to legislation, LASPO, the money laundering regulations. So to give you a specific example, this could be where we are trying to remove something that exists elsewhere in legislation. For example, in the current Code of Conduct in Chapter 6 and Chapter 9, we talk about the fact that you must not pay a prohibited referral fee and you are not paid a prohibited referral fee. So in our new approach, neither outcome will feature in the new codes because they simply reflect the legislative position in the Legal Aid Sentencing and Punishment of Offenders Act and also in the Criminal Justice and Courts Act. Another example is the requirement to comply with law. Again, we see this as a duplication and we will be removing this from our new code in our proposed drafting. So some examples are set out on the slide in the current Code of Conduct, where we have outcomes such as when deciding whether to act or terminate your instructions, you comply with the law and the code. So these are simply requirements where we are stating to comply with the law, and therefore we see them as unnecessary duplication. Again, another specific example is removing repeated references in the proposed new drafting to things, for example, as client's best interest. You'll see that I've set out on the slide that in the current code, there's just 4 examples of where we mention acting in a client's best interest or protecting their interests. And we also, within the new proposed principle, will be including proposed principle 6, as used to act in the best interest of each client. So we don't feel that there's a need to duplicate this requirement in the actual body of the draft codes. The fourth example in relation to removing duplication is the removal of the client money principle, and that's existing principle 10, and we're looking to move that to become a new standard, and that new standard will feature in both codes. That's our proposal, and it will be that you safeguard money and assets entrusted to you by clients and others. The third feature I wanted to mention is the intention of trying to strike a better balance between still assuring client protection, but also maintaining proportionate regulatory burden. So I'm going to ask Amanda briefly to return to this topic in terms of allowing solicitors to practice in unregulated firms.
Okay, thanks, Jessica. Yeah, so our proposal, or at least our consultation position, is that the Code of Conduct for individuals will apply to all solicitors wherever they're working, whether they're working in a regulated or an unregulated entity. However, we did set out within the consultation a number of policy issues, and I think it's quite important to say that these are our consultation positions, and we'd be very interested to hear views from people. Obviously, under the code, solicitors have a duty to safeguard money and assets entrusted to them. But we're proposing in the consultation that solicitors who are working in unregulated firms don't personally hold client money, that the compensation fund and the PII requirements do not apply. But we have also included a new standard for solicitors to make clients very clear on the position of which regulatory protections apply to them. So within the consultation, we've set out the regulatory protections that currently apply to solicitors working in regulated firms, and you can find this at paragraph 107 of the consultation. And the regulatory protections that currently apply to those clients who are getting services from alternative legal services providers. So the third line in that infographic sets out the regulatory protections that will apply to the solicitors, and these are, in the main, ones that are attached to the individual code.
Another element of solicitors working in unregulated firms that is a protection that will be in place for consumers and also make it easier for consumers to know who they're dealing with is that businesses won't be permitted to use the title solicitor. And this is something that we've mentioned in the consultation as a proposed policy position, but it's actually something we'll be looking at in more detail in phase 2 in terms of our proposals for authorisation and practice requirements.
I think it's probably worth just bringing in here, because we've had some questions about this issue of solicitors working in alternative legal sector, just answering a couple of those and picking up on a couple of the themes that have been coming in, and I know this is something that interests a lot of you. First of all, we had a question about whether these changes would make a difference for in-house solicitors, and in particular, would they be freed up to provide services such as pro bono services? As you may know, the current practice framework rules put a restriction on solicitors from working outside of an authorised or regulated firm unless they comply with Rule 4 of those rules, which provide quite specific restrictions around what in-house solicitors can do and who they can work for. The proposal is to remove Rule 4, get rid of all of those restrictions. What that would leave us with, though, is the requirements in the Legal Services Act, that's Section 15(4) of the Legal Services Act, which set out the principle that where a business is providing reserved legal activities to the public or the section of the public in the course of their business, then they will need to be authorised. What we're planning to do is put some guidance out on the website in our FAQ section, which explains how we see Section 15(4) working, how it applies, and a sort of decision tree to help people understand how we interpret that section. But the idea for our changes is that we would be removing any additional restrictions, going back to just what is in the Act in terms of providing restrictions there. I think it's also fair to say at this point we've been asked a question about whether in-house practice is considered to be part of this alternative legal sector. Well, we do think that when we're talking about the alternative legal sector, that is individuals who are providing services externally to the public, not those who are in what one might call more traditional in-house role.
So in terms of the fourth feature of the code that I wanted to highlight, that was our intention in terms of approach was to identify any gaps that existed in the 2011 code. So we've gone through in our review in terms of drafting these two new codes to look where there are any regulatory gaps that we can identify, and in doing so we've then sought to draft new standards. So I can give some examples of those, and I'll try to go into a bit more detail. So the first example is a proposed standard in the code for individuals. These are examples of new standards, as I said, that we consider to be gaps that existed in the current code, and ones that we wanted to create new standards. So the first is dispute resolution and proceedings before courts, tribunals and inquiries. So we have in this section, which is section 2, introduced two new standards. The first is that you only make assertions or put forward statements, representations, or submissions to the court or others which are properly arguable. And the second new proposed standard is that you do not waste the court time. The next new standard that we're proposing, that I'll give an example of, falls under the category of supervision and accountability. And I know that we have had some questions relating to supervision, so this is a good standard to target that. So we're proposing a new standard 3.5 in the Code for Individuals, and that will be that where you supervise or manage others providing legal services, you may remain accountable for the work carried out through them. And this is to reflect an element of the professional principles in the Legal Services Act.
And just to be clear, Jessica, I'm right in thinking this applies to solicitors wherever they work. So this is those working in-house, those working and managing teams in an alternative legal sector, but also those who are working in authorised firms.
Yes, that's absolutely correct, yeah. The second example of some proposed new standards, which actually are in both codes, the Code for Firms and Code for Individuals, relate to continuing competence. So this is a focus area for us. This falls in line with our Training for Tomorrow projects, and in particular our statement of solicitor competence, and also the proposed and upcoming alteration to CPD requirements which affect solicitors. So in terms of these proposed new standards, we are suggesting the following new standards. So 3.3, that you maintain your competence to carry out your role and keep your professional knowledge and skills up to date. Another new standard is that you ensure that the individuals you manage are competent to carry out their role and keep their professional knowledge and skills up to date. The third standard relevant to this continuing competence is that you ensure that your managers and employees are competent to carry out their role and keep their professional knowledge and skills up to date. And finally, that you have an effective system for supervising clients' matters. So this is continuing competence and also a link to supervision requirements. A third example of a new standard can be found in our section entitled Cooperation and Accountability Information Requirements. And these are the standards that I referred to when I talked about streamlining, flexibility, and removing prescription and having much more high-level purposive standards. So we've added in there a new proposed standard that you keep up to date with and follow the law and regulation governing the way you work. The final set of examples that I'd like to run through briefly are ones that we've put in light of the world that we're living in today, in terms of the threats that firms face in terms of problems with IT security, and also more and more circumstances relating to money laundering and such like. So the first example falls under the category of client identification. So we've introduced a new standard that you will take appropriate steps to identify who you are acting for in relation to any matter. Moving on from that, we've included a new standard relating to obtaining instructions. So we're proposing a new standard 3.1 that you only act for clients on instructions from the client or from someone authorised to provide instructions on their behalf. If you have reason to suspect that the instructions do not represent your client's wishes, you do not act unless you have satisfied yourself that they do. Finally, the last example relates to the complaints handling provisions and new ADR signposting requirements. So this will bring in a new standard 8.4. And this is to reflect, as I say, the new ADR directive requirements. So this will be that you ensure that clients are informed in writing. If a complaint has been brought and your complaints procedure has been exhausted, 1, that you cannot settle the complaint, 2, of the name and website address of an alternative dispute resolution approved body which would be competent to deal with the complaint, and 3, whether you agree to use a scheme operated by that body. I'll now hand back to Juliet so she can give you a bit more detail about our approach to enforcing.
Yes, I just think it's worth just pausing a little bit to think about our enforcement strategy before Amanda kind of concludes the slides by talking about where we're at in the consultation and next steps, because I think that just as important as the words on the page in the code is how we actually enforce in the SRA and our approach to compliance. Many of you may have heard about or been involved in our Question of Trust campaign, ran over the end of last year into the beginning of this year, and it was a campaign in which we gathered well in excess of 5,000 views from individuals, both members of the profession, members of the public, consumers, and stakeholder groups. They gave us our views on a series of vignettes, a series of scenarios, telling us really, we took the temperature of how seriously they viewed those scenarios, whether they thought they were a matter that we should be interested in as the SRA, and if so, how seriously we should take it. Hugely important, very, very useful, and what we're doing with the information that we received out of that campaign is we're using it to help shape and inform a new and revised enforcement strategy. I think what is clear to us, particularly when you're moving to a more kind of principles-based, high-level code, where things go wrong, we need to look at the context, we need to look at the circumstances, we absolutely need to take a proportionate response, and really what that involves doing is focusing on where those issues indicate there's a real risk to the public interest, to our public interest purpose as a regulator. And what I mean by that is protection of consumers, but also to the rule of law, to the administration of justice. So the new strategy is going to provide some information about the factors that we think affect the seriousness of an issue and really touch on those public interest factors. But also it's going to look in a little bit more detail about who we enforce against, as well as what kinds of issues we enforce. And I think inevitably one of the things that we'd like to achieve from this new approach to a code, having it split between individuals and entities, is provide much greater clarity about the issues that we believe individuals should be responsible for in terms of their sort of professional standards, and the kinds of things that we think entities should be held to account for, the things that they should be doing in order to comply with our requirements. So with that higher level code and with that flexibility, that's giving much more judgment to those who are operating within the code to understand how it applies to their individual circumstances, how they should try to arrange their business to comply. And I think that's really important. We need to use our judgment wisely then, also in terms of what we enforce and how. And I think through the code, what we're trying to do really is provide this sort of framework of competence and ethics to help firms understand our standards, how they can be met. And we think this new approach will get us into that position in a much better way than our current approach. It says here on the slide, we expect to consult on the enforcement strategy in late 2016. What we understand at the moment is that we'll go out to consult end of this year or beginning of next. We're working at the moment on reviewing all of the question of trust responses and putting that into a strategy which we can come back out to consult on. I'm going to hand over now to Amanda to let us know where this fits into the whole timeline.
Okay, thanks, Julia. Yes, so the consultation on phase 1, which is the principles, the code, the conduct, and the policy issues around the practice framework rules, opened on the 1st of June this year. We've actually chosen to go for a 16-week consultation, partly because we think this is very important, and also because we want to engage with as many stakeholders as possible as we can during the consultation period. In terms of phase 2 of the review, we have started work to look at all of the other rules and regulations within the SRA Handbook. This would include the detailed rules for the practice framework rules, also looking at our authorisation rules. Juliet's already mentioned the enforcement strategy. We will be planning, I think, to actually consult on that in line with the timetable for consulting on the enforcement strategy. So it's likely to be in the early parts of next year. In terms of actually bringing in the new regulatory arrangements, it will certainly not be any earlier than late 2017. It may be a little bit later, it may be in 2018, because it's so crucially important that we actually get this right. So in terms of the stakeholder engagement, we touched on case studies a couple of times as we've gone through this session. We're really, really keen to hear from people. Actually hearing about real examples in practice will really help us to develop a set of case studies that actually help people to interpret our rules. If we develop these in isolation, there's a real risk that we develop case studies that are very black and white. And we know from talking to stakeholders that the real challenge lies in the grey areas. People can upload case studies, responses, immediate questions to our Looking to the Future, our SRA Looking to the Future website. There's an interactive function on there that we really would encourage people to use. Anybody who has been part of this webinar today and would be interested in being part of our Looking to the Future virtual reference group, please do let us know. We're keen to get as many people involved in that as possible. Also, as we mentioned in the consultation, we are planning to put together quite a comprehensive toolkit, and we're very open to working with individual firms who are developing their guidance to help them with that process if people find that useful. So again, it let us know if there's anything that we can do to help you. And the other thing that we just wanted to add was that in advance of these changes to our regulations coming in, we're actually keen to be engaging with people who want to innovate but find that they can't innovate at the moment within the regulatory framework that we have. So we also have on our website an SRA Innovate webpage. And again, we really would encourage people to get engaged and to make contact with us, because it may be that we're actually able to help you to introduce some of these innovations while we're going through the consultation process. Juliet, we've got some questions.
We have a few. I think we probably have time for a few more questions. There's one that we had here about how we understand or quantify unmet legal needs, and I think it's important. I know I mentioned that in my introduction. I just follow that up really by saying that we have looked at, there's an awful lot of research out there that we've drawn on, and we have looked at various different pieces of research looking at different parts of the market. And what we know is that there is an issue. This tells us that about 8 out of 10 people who experience what can be identified as a legal issue, a legal problem, and of course that can be cast in a number of different ways, but the research looks at different kind of measures, don't go to a legal professional for help. They may try and look after it themselves. Sort of DIY law is an increasing issue. And we know that the statistics are similar for small businesses who will often choose, they recognise that, that it's important to get legal help for problems, but will often choose to go to, say, an accountant before going to a legal professional to look after their problems. Some of the reasons for this, well, we have some information that suggests this is to do with affordability. And we also know that there are some issues with trust in the profession, and particularly that people find the justice system intimidating. So that may suggest people are reluctant to identify their issues as legal problems in the first place. I think it's a very interesting area. I think one thing that we know is that there is certainly an access to justice issue there, but also an opportunity for firms. There is unmet need out there and people who need the services of legal professionals.
So there's another question, which I don't think we have covered, and although we have in part, about why we're doing such a comprehensive change when we made such a comprehensive change in 2011.
Yes, certainly. Well, I think, going back to the points I made at the beginning, I think this is really a point in the market where we recognise it's changing dramatically, and we want to make sure our regulation is fit for purpose. The points that we mentioned before about the unmet legal need and our need as a regulator to consider that issue and access to justice as well as consumer protection. So this is an opportunity, I think, which we have to take in order to try and address that.
And I think that's absolutely right. But I think there is another sort of layer to it in terms of the 2011 Handbook, which is that when that was developed, it actually brought in quite a lot of old material that's never been fully reviewed. And so as part of the review, it seems a really good time to look at all these again and to start really with a blank sheet and work out what regulation we need, what rules we need, and what is clearest for the people that we regulate.
We've also had a question, somebody reasonably asking whether or not this would have included the proposed changes to the accounts rules, and whether or not there'll be a separate webinar.
Sorry, I can chip in there and just say this is the first of a series of webinars we're doing through to the end of the consultation period. They're taking different topics so that we can, this is for those who might not have seen, we launched 2 consultations at the same time, both running to the same timeline. One was on the new codes of conduct and the principles. The other was on changes to the SRA accounts rules. We absolutely recognise there's a lot in them and there's a lot of information. So we wanted to put forward a series of webinars that we're going to look at various different topics and issues in turn. I think we have time for just one more question.
Okay, I think so we had a question which is asking, will everything be rolled out together or will it be rolled out piecemeal? No, it will all absolutely be rolled out together, although we're consulting separately, and we also have consultations going out in the autumn on our compensation fund. We'll bring the whole thing together and bring in one set of regulatory arrangements and we're sure we've got the right ones.
I think that's probably all the questions we've got time for, but I think our intention is to gather all these questions up and
we'll answer them through the FAQ section of the consultation webpage.
Yes, so I think I'd just like to finish off by thanking everybody for listening.